Absolutely. Wills and trusts offer the grantor certain privileges. The main difference, is that a will is only effective when the person passes away. Trusts are effective during the lifetime of the person. That's one of the key differences. Estate planning covers a lot of areas. People think that they need to have wealth, properties to do estate planning. That's not exactly true. Now, younger people may not feel that they need estate planning, but part of the estate planning documents are healthcare documents. So they become incapacitated even at an age of 18 plus. Somebody needs to step in and handle their medical affairs. That's a very important reason for estate planning. One of the misconceptions people have with estate planning concerns trusts. People believe that if they put assets and property into a trust, that it's protected from lawsuits. Well, only the homestead property is. Otherwise, there are concerns. Well, durable power of attorneys are effective when the person is alive. Wills are only effective when the person is dead. Now, a person may need help for finances or healthcare if they become incapacitated. That's where the power of attorneys come into play and are excellent documents to have. A healthcare directive, sometimes referred to as a living will, is a document used for end of life to determine whether the declarant wants to be kept alive on machines or not. It is helpful for the family if they've made that choice in order to take that difficult decision away from the children and or the rest of the family. That's an excellent question. We have a lot of blended families that come to the firm. There are marriages that husband and wife have been married before. They have children from different marriages. And that's a special kind of situation where we recommend a trust, where each of the grantors, each husband and wife, can decide how best and the easiest way to disperse their assets when they pass. So this is a way to put it in writing and avoid conflict with the children after they're gone. Leaving assets to a minor is a very awkward position. In the state of Florida, 18 is the age of majority. So if assets are left to a person under 18, their guardian, and if it's their parents will be in charge of those assets until they're 18. However, at the age of 18, depending on how the asset is worded, could go to them as an outright distribution. And an outright distribution of a healthy asset could be dangerous for the 18-year-old. That's another good question. Yes, you can disinherit a spouse or a child in your will. You can do that. However, there are special considerations for husband and wives in the state of Florida who own a homestead property. One cannot disinherit the other. Probate is a lengthy public court process that can cost heirs a lot of money. Basically, it could be in the state of Florida about 5% of the value of the assets. One way to avoid probate, if it pertains to a property, a real property, is to put that property into a trust or design a life estate deed to this property. As far as banking and other investments, it is wise to put beneficiary designations on those accounts, and that's another way to avoid probate. Safest way to do that is through a revocable living trust. It would be wise that the grantors also seek the advice of a tax professional and or tax attorney, especially if their assets are huge.